We're live.
All right. Good afternoon, everyone. I am Alex Williams, the chair of the Commission to Restore Trust in Policing. I want to welcome you to our August 24, 2020 meeting at 2. As some of you know, Zoom has had some problems this morning going in and out, I'm told. But supposedly the problem is fixed now. And I will say if Zoom fails and any members of the public are not able to see or log in or stay logged in, and for any other reason that the service is interrupted, please call in, let us know immediately, and we're going to adjourn forthwith the proceedings and reschedule it. But right now it seems to be working. This is our third meeting since resuming our activities that were previously suspended due to the pandemic. At last meeting, at our second meeting, a couple of weeks ago, the commission was updated by its counsel regarding a number of possible statutory and policy changes to restore trust in policing. Today, we have an agenda and we plan to discuss these recommendations in a bit more detail in order to conceptualize our final written recommendations. We have a modest agenda today. We will first hear from Attorney Michael Davey, who is a partner at the law offices of Schlachman, Belsky, and Wiener. You all remember that at our last meeting, we heard from the Baltimore City Police Department. Among other things, the commission was briefed by the department on a letter it wrote to the commission that outlined certain recommendations to amend the Law Enforcement Officers' Bill of Rights. The letter has been posted under the meeting materials on the commission's website for those who have not seen it and may want to see it shortly. So in response to the letter, Mr. Davey wrote to the commission raising some issues. So we wanted to give him an opportunity to join the meeting today and to brief us in a bit more detail about the issues or his concerns. So with that in mind, Mr. Davey, you're here. Welcome. The floor is yours. And I'd ask the commissioners if we can hold our questions until Mr. Davey is finished with his presentation. Mr. Michael Davey.
Thank you, Your Honor, and thank you to the members of the commission for allowing me to appear here today and discuss my response to the letter written on behalf of Commissioner Harrison and his recommendations to the Law Enforcement Officers' Bill of Rights. I think probably the first thing that needs to be understood is the Law Enforcement Officers' Bill of Rights is a statewide bill. It doesn't just affect Baltimore City. There are 148 law enforcement agencies in the state of Maryland and over 16,000 police officers. Commissioner Harrison, based on his letter, is basically trying to speak for the chiefs of every one of those 148 agencies. I don't think that's what he's intending to do, but that's actually in reality what he's done. He's making recommendations that will affect, if amended, would affect every police department under the LEOBR in the state of Maryland. A couple just misinformation that's out there on the LEOBR itself. There's been a big issue about the dissemination of police internal affairs files and investigations on police officers. That has nothing to do with the LEOBR. That's a separate issue in itself. The argument about qualified immunity has nothing to do with the LEOBR. It's an issue by itself. A lot of times, it just seems recently, the Law Enforcement Officers' Bill of Rights has become the scapegoat for some of these organizations that use those letters in order to push their own agenda. You know, not too long ago on WBAL, I heard a member of the Baltimore City Public Defender's Office claiming they can't get internal affairs file because of the LEOBR. And that is just a complete misstatement of the law. The LEOBR does not have anything to do with the MPIA or the request under the Public Information Act. It just simply, they're not related at all. Getting back to the commissioner's letter, the commissioner has made some very dramatic and drastic recommendations for amendments to the LEOBR. And I'll just kind of, probably the best way to do it is address it and go through it the way he did. So he wants to expand 3107 to include conviction or probation before judgment of a misdemeanor or a felony. Well, right now, the Law Enforcement Officers Bill of Rights indicates that if you are in fact convicted of a felony, you can be terminated without a hearing. Adding misdemeanors to that adds a whole broad scheme of what we're talking about. That's a lot of crimes. He hasn't really said whether it's issues involving the job or if it's something off duty. And the issue involving a PBJ, as you all know, a PBJ in Maryland is not considered a conviction. But a PBJ, because of the law not being a conviction, we would obviously be opposed to that. A probation before judgment, if accepted by an officer, that in itself should not cause for their immediate termination without the right to a hearing under the LEOBR. Another recommended amendment was the ability to terminate officers who are charged with a felony or a misdemeanor or are highly likely to be charged, pending a review of the evidence in the days immediately following the criminal incident. So we've now gotten away from getting a conviction. Now the commissioner wants the ability to just fire somebody if they're charged. That really has a major effect on someone's ability to have due process. Due process is a constitutional right. Police officers, as public employees, have a due process right to their job. It's under the 14th Amendment. I have it right here. So basically, the 14th Amendment talks about no person shall be deprived of life, liberty, or property without due process of law. Further on, the Supreme Court held that public employees do have a due process right and a property right to the job, and therefore they do have due process. Being able to terminate someone from their job just because they're charged clearly, in my mind, violates any kind of due process issue that they would have, especially when we're talking about felonies, misdemeanors, and I don't even know what highly likely to be charged means. That is about as subjective as you can get. Just because the commissioner thinks he might get charged with a crime or she might get charged with a crime, he just wants to be able to fire them. Really smacks in the face of a violation of an officer's property right and due process. The commissioner's letter talks about a couple cases as it relates to these charges. One of them, an officer WC. I'm very familiar with that case. And I'm surprised they use that case because that actually is an example of how the system works. That officer was charged with a felony. That officer was immediately suspended without pay while a criminal investigation was, while his prosecution went forward. He wasn't getting paid. He wasn't getting health benefits. He wasn't earning pension credits. There was nothing negatively affecting the Baltimore Police Department other than his name still being on a roster somewhere indicating that he was suspended without pay. That officer was eventually convicted of a felony and he was immediately terminated without a hearing. That's what the LEOBR does, and that's what happened in this case. So like I said, I'm somewhat surprised why they would use that as an example. They also use the examples of Officer RP and Officer CRM. Those officers were in fact charged with misdemeanors. They were kept on payroll for whatever reason. While their case was being criminally investigated, they did not do an administrative investigation. They just sat back and watched it occur. It wasn't until they actually were convicted that they decided to start an internal investigation in that matter. And in fact, I think I have it in my notes because I researched it. RP and CRM were on payroll for probably a year or a year and a half later. They weren't administratively charged, and they weren't eventually even scheduled for a trial board until the month of August of this year. Again, that's not an LEOBR issue. That is a mismanagement issue on behalf of the police department. There is nothing in the LEOBR that prevents a criminal investigation and an administrative investigation to be run simultaneously. The only issue that comes up is the internal investigation, their ability to interview the accused officer. Again, that's not even an LEOBR issue. That's a Supreme Court case called Garrity versus New Jersey. In Garrity versus New Jersey, the court ruled that a police officer, if he's ordered to give a statement, that statement cannot be used against him in any criminal matter that he's pending. So the department could have done their full investigation. They could have administratively charged both of these officers, and upon their conviction or whenever they wanted to, they could have moved forward with administrative charges and eventually a hearing board with or without the officer's statement. What took them so long is their own mismanagement. There's no other reason for it. They simply lost track of these officers, and it was a management issue and not an LEOBR issue. They talk about a possible amendment to expand the ability to suspend officers without pay to and includes certain misdemeanors and other non-criminal violations that could lead to termination. Again, these are very subjective terms. If you look at the Baltimore City's disciplinary matrix, I believe they have 74 categories. And of those 74, I believe 55 to 60 of them go from an A violation to an F violation, which is anything from a counseling form to termination. So the police commissioner could just say, well, the officer's charged with neglect. That could be anything from an A to an F. It's an F. We're just going to suspend them without pay and figure it out later. That's clearly not fair to the officer when it turns out he may be non-sustained. The case may resolve with a non-sustained, exonerated, or an unfounded finding. And therefore, it's simply not fair to the officer to have his pay suspended for that type of an issue. They also indicated that one of the reasons they wanted to do this is an officer who's suspended without pay has little of incentive to cooperate with the administrative process. That just doesn't make any sense. The officer wants to keep his job. Of course he's going to cooperate, and he'll be ordered to cooperate. And if he doesn't follow that order, he'll be administratively charged with that also. He has no choice but to cooperate in an investigation. They gave an example of DN and JP, who in their minds, again, the Baltimore Police Department's minds, they couldn't interview the officer because they went out on stress medical leave. Nothing in the Law Enforcement Officer Bill of Rights indicates that you're out on stress medical or any other kind of medical leave can prevent them, or meaning the officer, from being interviewed. Nothing. They could have brought him in. They could have been interviewed. If the officer didn't come in, that would be on the officer, and he would likely face a failure to obey an order charge. But again, you can't blame the Law Enforcement Officers Bill of Rights for the police department's mismanagement and knowing what they can do and what they can't do. The department recommended changes to give the commissioner greater discretion in the management of the agency post-trial. The department cannot challenge the exoneration of an officer by a hearing board that did not follow the evidence. So the police chief basically wants to say that I'll pick the trial board, I'll pick the members, I'll select who's going to hear the case, but if they find the officer not guilty and I don't like it, I want to be able to reverse it and find them guilty. Again, that completely violates an officer's due process right. There is no court that I ever heard of, criminal court, civil court, where that can happen, where it can just be changed just because the commissioner didn't like the outcome. Again, they gave examples, let me find it, of AS and CS. I'm very familiar with that case. I handled it. What they provided you was information on why the department believed they had sufficient evidence to find both of those officers guilty. I think I explained in detail in my letter all the things in that investigation that weren't done, which led the trial board members to determine that these officers were not guilty of what they were charged with. The investigation was poor, it wasn't thorough, The prosecutors and the hearing board did not call witnesses, and I was very surprised they didn't, but they didn't call certain witnesses that may have helped their case. But again, the chief, it's the commissioner that has the ability under the law to pick the individuals who are going to sit on a trial board. I don't pick them. They put their pool together. I would imagine the commissioner would put people in that pool who he believes have been trained, are intelligent, who can make sound decisions. If they found them not guilty, the commissioner surely cannot have the ability to overturn any of those decisions. Another recommendation by the commissioner was to change the rules as it pertains to increasing the punishment. I think they called it numerous procedural restraints. So after an administrative trial board, and if the officer is found guilty, the hearing board makes a recommendation to the police chief or the police commissioner. He has the absolute right under the Law Enforcement Officers' Bill of Rights to increase that disciplinary action. His numerous procedural constraints consist of 4 things, and 4 things only. He has to review the record of the proceeding of the hearing board. He has to meet with the law enforcement officer that allows the officer to be heard on the record. He has to disclose in writing before the meeting with the officer to what oral or written communications that he's going to consider outside of the record. And he has to state on the record the substantial evidence in which he relied on to support the increase. Four procedural issues have to be accomplished. I don't believe that's numerous by any means. I don't think it's difficult. Police chiefs throughout the state aren't having problems with this. They cite the one case of AR, which I'm familiar with. The trial board or the hearing board found that officer guilty of some violations. The commissioner wanted to increase the disciplinary action. He reviewed the record according to him. He notified the officer and gave the officer the opportunity to speak on the record. Unfortunately, he considered something outside of the record, and he indicated that he did that when he had his meeting, which violated the policy. The officer filed an appeal. He won the appeal in the circuit court, and I believe it's pending in the Court of Special Appeals right now. But I don't believe that 4 simple procedural issues would require a change in the Law Enforcement Officers' Bill of Rights for an appeal, or for a recommendation for increasing a recommended disciplinary action. The department was recommending limited judicial review of an agency decision only to the substantial evidence test and eliminate the right to procedural grounds, according to them, due to minor technical violations of the statute governing post-trial procedure. Well, winning a case on an appeal, and I think Peter and Megan know this well, winning an appeal on a petition for judicial review on substantial evidence is extremely difficult. Basically, the only thing the department has to put on the record is that some evidence, a little bit of evidence that indicates that the officer may have done what he did. The trial board finds him guilty and he recommends punishment. To eliminate what they call minor technical violations, such as a violation of the Law Enforcement Officers' Bill of Rights, a violation of the reduced procedural violations that pertains to some evidence coming in, objections that were missed or should have been ruled differently. I can tell you if we do 15 trial boards a year, we may appeal 1. We're not talking about a lot, but what the commissioner's talking about is the ones he loses. And again, because he can't manage it correctly, again, it comes back to let's blame the Law Enforcement Officers' Bill of Rights. The commissioner talked about eliminating all collective bargaining options and the formation of hearing boards that are currently provided. to increase the perception of independence in a hearing board. So collective bargaining agreements, am I still here?
Yeah, Mike, you're going in and out, but we're hearing you.
Okay,
Yeah,
I'm sorry.
keep going.
So collective bargaining agreements are just that. They're agreements between the union and the department. These agreements are not forced upon by the department. They don't have to agree to them. And if there wasn't an agreement, they wouldn't be in the MOUs. So in the Baltimore City MOU, we have an agreement on trial board selection that it would be done randomly. We get 3 total strikes on the chairman and the members of the board. Just recently, we negotiated civilians on trial boards, which are part of the MOU, not part of the LEOBR per se. While the LEOBR allows with legal authority to do it, the FOP agreed to having 2 civilians on every trial board, how they would be selected. We have now gotten away from the ability to strike members of the board. We've come up with a new system for that, where the police commissioner selects 25 members of each rank who could be sitting on the board. We get to eliminate 5 from the beginning, and then whoever gets picked gets picked. So the collective bargaining agreement, not every department has collective bargaining. And again, the commissioner speaking for everyone, not just his own department, since this is a statewide bill. But these collective bargaining agreements, probably the most important thing is the unions have given up other benefits or other possible benefits, working conditions, salary, in order to get these conditions in their contract. The cities, the towns, the state, they have agreed to them. And that shouldn't be eliminated simply because now Commissioner Harrison doesn't like what was negotiated before he got here. The one thing I will add when it comes to the civilians on trial boards, the FOP negotiated that back in December of 2018. That is when it was ratified. We are now in almost September of 2020, and they are almost finally done with the training. So we're talking 19 months roughly for this to occur. Again, this wasn't an issue for the Fraternal Order of Police. It wasn't an issue on the LEOBR. It was simply making this a priority by the department, which it didn't do up until recently. This training didn't start until June of 2020. As it pertains to allowing civilian investigators, I don't think anybody's going to have a real heartache over that, as long as there's some qualifications for somebody to do those investigations. It has to be more than just a citizen with no training on how to do it, no police experience, no background. I think there are ways of making that work. And finally, there's a recommendation for subpoena power during the investigation. I don't think anybody's really going to have a problem with that. It makes sense, actually, to me, because the way the system's set up now is they cannot get it until the officer is charged. So I don't think that's something we'd be overly concerned about. So when I read the commissioner's letter, I tried to think of what would be the rationale for wanting to make these dramatic changes. And there's really only 2 that I can come up with. One, that Commissioner Harrison is not familiar with the Law Enforcement Officers Bill of Rights. He doesn't understand it, or he just doesn't want to deal with it because he didn't have to deal with it in his prior police department. The second reason is it's just mismanagement by their own department. Like I stated earlier, there's 148 police departments in the state of Maryland. No one is having these issues. Every other department, and I represent 55 unions throughout the state. My firm does 55 units, and we probably have another 10 that we also do work with. So 55 on retainer, 10 that we do additional work for. And these issues are just not in many other places. I've been testifying in Annapolis probably for the last 5 or 6 years. At no time has any police chief come to Annapolis and said, we need these changes that are being recommended. by Commissioner Harris. It's never happened until now. So I guess I would leave it with, I believe that these recommendations are based on the department's frustration that they cannot manage their own house. They cannot do it. They can't do it right. So therefore, instead of trying to work within the law that's currently there, like every other police department does, they just basically want to gut it to make it work for them and make it easier for them. When I read the letter from the commissioner, that's kind of got my head thinking, and that's why I responded in the manner that I did. I felt it was important for you to get a true picture of not only the other side of their recommendations, but I felt it was very important that you get a true picture of the cases that they cited and why the citing of those cases really were just an attempt, in my mind, to mislead you as to the need for some of these dramatic changes. And that's why I wrote the letter. Thank you.
All right, thank you, Mr. Davey. We'd had some problems, and your audio was good. The video, you're back.
Yeah, I just clicked on it.
Okay, great. Let me, before we ask for any questions, let me go back and again have all of the commissioners. We have all the commissioners with us today, all 7. And let's just go around the and ask everyone to introduce themselves. As I said before, I'm Alex Williams. I'm the chair. So let's go around and get all the other 6 commissioners to introduce themselves.
Commissioner Jim Roby from Howard County.
Right.
Alicia Wilson I'm an attorney and I'm in Baltimore City.
Inez Rob, Baltimore City. Baltimore City Western District Community Relations Council President.
Right.
Sean Malone, I'm an attorney with the law office in Baltimore County resident.
All right.
Gary McElhenney, I'm the Assistant Secretary for the Maryland Department of Public Safety.
Ashia Parker, I'm the Executive Director of No Boundaries Coalition and a resident of West Baltimore.
Okay, great. All right, so that completes all 7 of us. So let's see if there are any questions from any of the commissioners to Mr. Davey. Your testimony was very helpful. Thank you so much. And we also received a copy of your letter. So your testimony with the letter is very, very helpful. Let's see if there are any questions.
Mike, go ahead, Gary.
Okay. I think I've said this before when Mr. Davies appeared before the committee. I think it's important that everybody realize I worked at Schlockman, Belsky and Wiener from 2007 to 2015. So I think it's important that be disclosed, Mr. Chairman. My question, Mike, is Chief of Staff testified it. I believe it was our last or the hearing before that when an officer is suspended without pay, they still get benefits. Is that in fact the case?
No, it's not in fact the case at all. They get no benefits. They do not get paid. They do not get health benefits. Their pension contribution is not made by either them or the department. Their name simply remains on a roster as an employee, but they get 0 benefits.
Thank you.
All right. Who else? Sean?
Yeah, sure. I think also, just for full disclosure, our firm has done some police conflict work on occasion. I don't handle those cases anymore. Michael, the proposal, so in the Baltimore Police Department's letter, they proposed that if an officer was charged, went through a trial board and lost a hearing, and prevailed in the hearing, was found not culpable, they were proposing that the chief could reverse that finding and implement punishment?
That's how I read their letter, yes.
Okay. Currently, the chief has the authority to increase punishment, but not change the finding of the trial board.
That's correct. When the hearing is over, if the officer is found guilty of any charges, the hearing board makes recommendations to the commissioner as to what the recommended disciplinary action should be. The police commissioner under the LEOBR today has the right to increase it, decrease it, or sign off on it. If he wants to increase it, there are 4 steps that I read into the record that he has to do. That's it. It's not overwhelming and it's not numerous procedural issues. It's not difficult. And honestly, since Commissioner Harrison's been here, he's not done it yet.
Is stress medical in the general orders? Is it an actual formal designation, or is it essentially medical?
It's simply medical. There's nothing in the policy that talks about stress medical. It's just an officer who's elected to go out on medical leave as a result of a stress issue. It doesn't prevent the department from taking someone to a hearing board, interviewing him. It's no different as the officer had a torn ACL.
Okay. If an officer is ordered to testify, not testify, to provide answers in interrogation, you touched on this, but I wanted to make it clear, and the officer refuses, they can be charged with insubordination?
That's correct. There'd be additional charge if they don't show up or they refuse to answer any questions. They can have an additional charge of failure to obey an order within the department.
Okay. And where in the matrix does that fall? Do you know?
I believe it's a D. I'd have to look at it. I don't have the matrix in front of me, but a D violation is anything from more than 15 days to suspension to and including termination.
Okay. I just had one other question. Just there, you obviously followed attention to this. You try these cases across the state. If in fact a decision was made to repeal the current law enforcement officer Bill of Rights, just talk about, give the commission a sense of what would step in its place if the state didn't have legislation in place.
So you would, under the Supreme Court cases and their property right to their job, they would still have some form of due process. What that would look like could be different in 148 police departments. Every agency could do their own thing. They can determine what due process is, what it's not, how it's going to work. So there would be absolutely no control by the General Assembly or any state legislative body as to what 148 police agencies are doing.
Are you aware of agencies that have incorporated the LEOBR into their labor contracts or their general orders?
Yes, some actually have. They've taken the entire LEOBR and made it part of the MOU. And those are usually done at the time when a police chief knows how to use the LEOBR, understands the LEOBR, can manage the LEOBR, and wants to give their employees the due process they're entitled to.
Okay. And you've done this, I guess, probably 20, 21 years now?
21 years.
Do you lose cases? Do you have officers fired?
I lose cases all the time. I win, and I put it usually like this. I win cases I should win. I lose cases I should lose, but it goes the other way too. I lose cases I should have won, and I win cases I should have lost. It's just, I lose cases. I don't win every case. If I did that, I'd be on retainer with 148 FOPs in the state of Maryland, but that's not the case. Most agencies do it right. They do a thorough, non-biased, independent investigation, and it's very, very difficult to win.
Okay. I don't have anything else. Thanks, Mike.
Thank you.
Your Honor,
Oh,
Yes.
sorry.
I have a lady speaking, so Commissioner, you certainly, I saw your picture in the magazine or paper or something.
Oh, no. That wasn't me, my twin maybe.
Oh, was it? Go ahead, I'll
All
follow
right.
you.
Commissioner Wilson,
Okay,
yes.
thank you. Mr. Davey, thank you for presenting to us today, and I appreciate your thoughtful remarks. I have just one question for you. As you look at the LEOBR, there seems to be, this is not an uncontroversial piece of legislation. And I just wanted to see if, as you reflect upon it, the way that it is written is how it's written. are there any changes that you would make to it? Are there things that, taking in the other side of the argument, recognizing there, good and bad on all sides of the points made, are there things you can say, you know what, actually, you as a commission, you set out with a mandate of attempting to restore trust in policing. I understand the pressure that is. I understand the realities of how things have played out. Are there things that you would say, yeah, this actually should be changed in the piece of legislation?
I think there are some definite changes that probably should be made. What they are in detail, I couldn't tell you. The problem is a lot of the broad categories of areas that need to be changed could be changed, and that those are the ones that does a PBJ mean a conviction? I think that's something we can work with and may need to be changed, but it has to be not just a broad brush decision. I think we have to look at each case, whether it be, if you're convicted of a felony, and even you get a PBJ for that felony, could you be terminated? But I think when it comes to the misdemeanors, I think look at what the misdemeanor is, whether it was job related or off duty. Did it affect the officer's integrity? So I think we'd have to get into detail more as to what exactly the issue would be, or the crime that was committed. I don't really disagree too much with the idea of civilian investigators, as like I stated earlier, as long as those investigators have some form of formal training, whether they be retired police officers or something of that nature. I don't think there should be an issue with that. Honestly, I think one of the changes should be in the LEOBR, there's a statute of limitations, which basically says that an officer, once the alleged violation or allegation comes to the attention of the appropriate law enforcement official, the department has 1 year to charge that officer, with the exception of criminal allegations or excessive force. But what the LEOBR doesn't say is how long do they have to put that officer before a hearing. In Baltimore City right now, I have 75, if not more, open trial boards. Some of them are for officers who were charged 2 and 2.5 years ago, that are simply sitting out there with no requirement to have them done. So I would hope, and I would recommend some kind of language that would say that a police department has to schedule a hearing board no sooner than 30 days, but no more than 90 or 120 days after the officer is charged. And if you look at the Baltimore City consent decree, that is basically one of the issues in the consent decree. If you look at the consent decree in paragraph 384, it talks about disciplinary hearings shall be scheduled within 30 days, or 30 days from the date the officer gets the charge. The agency will use its best efforts to ensure that disciplinary hearings will be conducted within 120 days of the officer being informed of the discipline. I think that not only helps the department, but it helps the officer to get what might be a minor issue off the books, no longer over his head. So I think an amendment actually putting a time requirement on the department to get that done would be extremely important. So I think some of these amendments can go both ways. And I think there should be a way to hold police departments more accountable for what they're doing than what's in the LEOBR right now. Because really the statute of limitations issue or the ability to file a show cause are really the two things that do it. It's the department that has complete control over the investigation, the scheduling, and the hearings. And they should be held more accountable into ensuring they're doing it in a timely manner.
Okay.
I apologize. I know I speak fast.
No, I think the real problem is that you were coming in and out. We heard most of your testimony, and hopefully at some point we'll ask council maybe to receive any of those comments with reference to any changes that can go either way, as you said. That may be helpful. Commissioner Wilson, anything further?
No, Your Honor.
All right, thank you. Again, Commissioner Roby.
Thank you, Your
This
Honor.
is,
Hello? One at
yeah.
a time. Who here?
Oh, okay.
Who's next? Commissioner Arnett? Okay, yes.
I was gonna, I would ask, Mr. Davy, if you were the, in charge of everything, the commissioner for Baltimore, Police Department, and you saying that you're thinking that the problems are mismanagement. So tell me the three policies or changes you would make to make management better if you were commissioner.
Sure, as it pertains to police discipline.
Pertains to whatever it is that you said, that as opposed to, you were saying that you thought there was mismanagement in all of the departments with the police department. I'm asking, if you were in charge, what if you were to come in tomorrow and say, okay, I'm here, what changes would you make to make the Baltimore City Police Department better at their management?
Sure. Well, I'm speaking today on discipline. I am not an expert, can tell you the best crime plan, but obviously fighting crime and ending criminal activity would be the #1 priority, however that needs to be done. But I think number 2 priority has to be the management of disciplinary cases. Disciplinary cases can ruin a department. We've seen it in the GTTF. It's given them a very, very poor reputation. The department has to figure out a way to manage cases in internal affairs. They have to be able to prioritize cases. There's got to be a better tracking system that officers' cases do not get lost. And that's exactly what happened in the P case and the CRM case. Those cases just got lost in the system. I can give you another example of a case, ma'am, where an officer was having problems at work. They ordered him for a show cause urinalysis, which basically means it was for cause. They believed he may be using drugs. That happened in December. He tested positive for opioids. They didn't conduct an investigation, and it wasn't until May, almost 6 months later, that he died of an overdose. Nowhere will you find that internal investigation because he got lost in the system. And that system is what's breaking down, and that system has to be fixed. There has to be a better system in place for tracking these cases. You have to take the high profile, the ones in dealing with integrity and dealing with conduct with the public, and make them a priority and get them fast tracked, as opposed to whether an officer was late turning in a police report or he was late for a meeting with the state's attorney's office. There has to be a way to prioritize cases, and that's not really being done right now.
Okay, thank you for that.
Thank you, ma'am.
You're muted, Your Honor.
Oh, I'm sorry. Commissioner Roby? Yes.
Thank you, sir. Thank you. This may sound sort of, I won't say silly, but strange to explain. But Mike, I know as you said, you've been involved with a lot of law enforcement agencies, a lot of people. I've known you over the years. You never did work for me.
No,
But,
I didn't.
I spent 8 years as chief of the Howard County Police Department, 32 years in all. And I had no problems with LEOBR. Our cases were promptly charged. There were decisions made. The defense came in, they made decisions. I increased the penalty a few times none of this dragged on the way it does in Baltimore City. Now, this is the tough part for you. What's the difference between Howard County back 15 years ago than today? Why did we have such an easy time with it? And I suspect a lot of my peers that were chiefs when I was chief, I never heard them complaining about it either, because of the problems they didn't have like Baltimore City is having. What's the difference?
Well, I think the difference is jurisdiction. One, today, compared to 15 years ago, the number of complaints are skyrocketed. There are way more complaints, even in Howard County today, than there probably, Chief, when you were there. The degree of complaints that are coming in, they have a mandate now in Baltimore with the consent decree that everything has to pull a number, everything has to be investigated. I believe last year they had over 4,000 complaints. There's a lot more of them, but there's no reason in the world that if a complaint comes in that an officer didn't turn on his body-worn camera, it should take 365 days to make that determination when they have his camera. The cases just go on forever. Again, I think prioritization is a big problem. They don't make discipline in Baltimore City a priority that it needs to be made. We just recently filed an appeal on 11 cases back in 2019, in which the department, in our belief, exceeded the statute of limitations. Like I said, they have 1 year to bring a charge against an officer. We found 11 cases, and since then we found 5 more that they missed the statute of limitation for charging an officer. We had to file a show cause in court. We won it in circuit court. Judge Fletcher Hill dismissed all of those charges. The department appealed it. We had oral arguments in May of this year in the Court of Special Appeals, and the Court of Special Appeals agreed with Judge Fletcher Hill, and those cases were all dismissed. Again, some of them were small, some of them were serious. But again, it should not be taking 365 days to handle an internal affairs investigation. When I deal with Howard County, Anne Arundel County, Maryland State Police, Hartford County, a lot of major jurisdictions, and they're knocking them out in 90 days. So again, I think it's just getting the work done and making discipline a priority.
Are you saying, Mike, that those of us, maybe in bygone years, put a larger priority because the community demanded it than is being applied nowadays?
Yes.
To get these things done in an efficient manner? I was, we're talking about restoring trust in policing. It seems to me like these things are always going to happen. Maybe not as many as Baltimore City is seeing or other large departments, but if these things could be resolved in an expeditious manner, consistent with the statute of limitations, a lot of this stuff might go away and you might get rid of a lot of bad officers sooner. And I think it would bring about more interest, more pride in the department you're working for if they weren't constantly being ripped and blasted in the paper and lawsuits and so forth.
No, I would agree. I think that again, and I don't want to, there are some changes that need to be done to the LEOBR, but again, I'm just going to go back to the consent decree. The consent decree now is requiring, even though it's not happening, I know, requiring that as soon as a complaint comes in from a citizen, that the department respond to them in writing, indicating that they received their complaint. And that has to be done within 7 days. And then the complainant is supposed to get periodic updates from the investigator as to what's going on in their cases. Again, part of the consent decree, it's something that has not been met yet. But again, it's putting more on the department for them to get people to trust that their complaints are in fact being investigated. So hopefully, once these provisions of the consent decree start being met, some of the issue as far as the public's belief that the police will investigate their own and do it right will be taken care of.
Just one last quick one. When do you think these decisions on the consent orders, when will they be implemented? So, I mean, how long have they been hanging there and not implemented yet? I know the judge wasn't too happy last time with some issues, but do you have any idea?
We're 3 years in right now. I don't know.
All right. Thank you, Your Honor. Thank you, Mike.
All right.
Thank you, Chief.
Yes, Commissioner Parker, do you have any questions that you'd like to ask of Mr. Davey?
I just echo the sentiment of Commissioner Wilson. If there are any updates or changes to these policies that will be helpful, if there are any compromises or anything that could help out BPD, we would appreciate if you could send a list of those over to us.
Yes, ma'am.
All right. Are there any other questions from any of the commissioners?
Your Honor, just following up on something that Chief Roby asked. Just so the commission knows too, and Mike didn't give his background, but Mike's a former state trooper who was the chief of staff to David Mitchell as well. So I think he played some role administering these on the other side of defending officers. But what Mike, would you be supportive of a statewide database or a requirement that jurisdictions have a database where people who have filed a complaint can follow the complaint through the different stages of the process, from complaint to investigation to charging to whether an officer's taken punishment or gone to a trial board, and the results of that?
Wouldn't be opposed at all.
Okay.
And as Mr. Malone stated, I did 20 years with the Maryland State Police. I retired as a captain. I investigated internal cases. I prosecuted administrative cases through the hearing board system, and I sat as their hearing board chairman for a period of time during the course of my career. So I've been on both sides of the fence. And believe it or not, I've been charged also as a police officer for violating policy. So I guess I've covered all of them.
All right, Mr. Davey, your statements and your presentation here has been very, very helpful. Let me say this: we all know that the Law Enforcement Officers' Bill of Rights is a hot button issue right now. Legislators looking at it, people are talking about it, and there's probably going to be some attention in the upcoming session. As the commissioners have already suggested, if you have any written suggestions as to things we ought to consider by way of amendments, let us know. I know this commission, and I've been with them for 2 years, that nobody desire to do and make any deliberate changes that's going to invite litigation and that sort of thing. We're not into that, and whatever recommendations we make, it's going to be well thought of. It's going to be balanced, because we think that we should take into consideration officers' rights as well as the public rights. And if there are any glitches in the system, we certainly would like to adjust it and to address it. So this has been helpful. You feel free to send any additional comments you have. And I, on behalf of the commissioners, I thank you for your presentation here this afternoon.
Thank you, Your Honor.
All right, so you may leave anytime you'd like. Yes.
Thank you.
Okay, great. Let's keep moving. We know that last meeting we had a discussion from our counsel at that point regarding some of the issues that he thinks are out there and so forth. So let me make a couple of points. At this item number 3, as you see on the agenda, we will now move into some discussion regarding potential recommendations and issues that need to be lifted up and put in our final report. Again, last week, our counsel presented us a number of possibilities, and that list has been sent to us by staff. We're looking at it. If there are any comments you have or suggestions or further discussion, please let us know and be prepared to discuss it today, next week, and the following week as we wrap up our report. I want to make it clear today that we will not be having any formal voting on any final recommendations right now. The dialogue we've had last week and we have today simply will be a basis for the written draft of our recommendations. And at some point, either next week or the week after, we'll start to have our final votes on the issues that we want set forth and described in our report. All of us got a list of those issues, and let me just mention what they are from my standpoint as I read the list. First of all, here's the list. Should the Baltimore Police Department employ systems and tactics to create greater accountability by the officers, such as integrity and polygraphs and financial audits and rotation of officers, etc.? And should there be elimination of plain clothes or street enforcement units? And we also need strategies to improve relations with the community. And that in my opinion, that includes greater community policing. Another issue was how to recruit officers with high ethics and intelligence to serve in Baltimore City. Third, how can we promote ethics and training at the police academy during field training, post-graduation exercises, in periodic training for all officers, and also in supervising training, including making reference to GTFF and the majestic towing and the George Floyd case and other misconduct situations that we have continued to see around the country. Other issue, how to create a culture of honesty, ethics, and compliance with the Baltimore Police Department so that officers will voluntarily report misconduct. Another issue, should police officers who engage in criminal misconduct forfeit their pension benefits? And would such a law effectively deter police misconduct? We've already talked about that today. Should police officers who engage in political, should the Law Enforcement Officers Bill of Rights be amended or eliminated? We've had discussions last week, this week, and that's got to be an issue that we've got to address probably in our report. Another issue, should there be a unit established within the Office of the Attorney General or the Office of the State Prosecutor or elsewhere with resources and expertise to investigate and prosecute major cases of police brutality, corruption, officers involved in shootings or deaths in police custody? Another issue, should there be legislation limiting police tactics such as chokeholds, tear gas, or use of force under certain circumstances? Should there be legislation requiring police officers to report misconduct by other officers with criminal penalties for failure to report? A few more, should there be greater citizen involvement in police discipline cases, and or should the adjudicated process for police discipline be revised or changed? Should there be greater transparency and more public disclosure of police disciplinary records? Should Maryland create, as Sean mentioned before, a database or registry of law enforcement officers terminated who've had misconduct or been convicted of criminal misconduct so that such persons are not rehired by other law enforcement agencies? And should there be any recommendations that the commissioners would like to address with reference to, again, I call it community policing. And also, as you all know, I'm very, very concerned about reinstituting the coordinating council in Baltimore City, which would have all the stakeholders meet periodically to talk about relevant issues of criminal justice. So those are my thoughts on the list that comes through, and we can now have any discussion, or if I've missed any critical issues that need further address, now is that opportunity to talk about it. So the floor is open right now.
Your Honor, it's Jim Roby. If I could, in going over the interviews that our attorneys conducted with current Baltimore City officers, it was interesting to see that a lot of things that I would speak about supporting, they were also supporting. For example, we've talked about the polygraph. You get a polygraph when you come into the department. And I know in our department, you don't get them anymore down the road. Baltimore City officers commented in there that they used to be polygraphs given for people going into assignments. And I'm sure Gary would know more about this, going into assignments where there was money, any other sensitive material before they transferred into that unit. And also the fact that people in those units, vice and narcotics and any kind of thing involving corruption or money could be polygraphed at least once, maybe twice a year at an undisclosed time, like a drug test. I like the sound of that. I really do, because I don't know how many times they would be able to do it in a year, but I know one thing, with that hanging over the head of a lot of officers, they're going to be thinking twice, maybe three times about, should I take the money off this person and stick it in my pocket? Should I take the drugs and do this shit? All these things to me that lend themselves to corruption, I think would be brought to light a lot more often, and you see a lot less of them. So I certainly support the issue of the polygraphs.
Yeah, I'd like to chime in here. Chief, I couldn't agree more. We used to do polygraphs in the Baltimore City Police Department in the narcotics unit. You're right, we took them upon entry. It's a requirement to become a police officer to successfully pass a polygraph. I think polygraphs as part of a routine, either random or annual requirement for those in certain specialized units that deal. And if you tailor the issue of the polygraph to integrity matters, I think you won't have an objection from the departments for cost and time and all that. This is not a 4-hour polygraph. It's probably a hour or two polygraph where you check on integrity matters related to their job that they're in. And I think that would be beneficial. Like I said, I think they got rid of them at the beginning of Commissioner Davis's tenure, but that issue needs to, they need to be doing those again. They were very important. I know when I was in narcotics back in the late 80s and 90s, we had them, and I think it's a tool that they're missing.
Any other comments on any of the issues?
The only thing I would say, Your Honor, I think that as we think about recommendations and ultimately what they will look like in to the General Assembly, I think we should think about making those smart recommendations in the sense of them being very specific, measurable and time bound. Given that I think it's important for them to understand of sort of when we think things could reasonably be done and when other things that might need to be prioritized, just because, receiving a whole list of recommendations is and having to prioritize them themselves may be difficult, given that they haven't sat through as many hearings as we have or heard the people in real time and understood the issues with the amount of proximity that we have. So that would be the only thing I think as we think about them, just lifting that up.
All right, Sean, do you have a report or summary of
Yes,
the
sir.
proposed changes under the Law Enforcement Officers Bill of Rights?
Yes, sir. I do.
All right.
I got
You
it.
want to run through those? Yes, with us?
I will. So at the chair's request, working with, first off, I really want to thank the council we have and the staff, Matt Jackson and all the legislative staff, Claire, for the hard work they do in supporting us. They've made this task doable. So through the course of testimony, we've heard a lot. We've heard from state's attorney. We've heard from the chief. We've heard from the FOP. We've heard best practices from other jurisdictions. And as we've gone through that, a lot of focus does end up on the LEOBR. So what I'm going to focus on in this presentation today, I think you guys received an outline, is to kind of walk through the statute and changes that we can put in place. And this gets to what Commissioner Wilson was calling on us to do with regard to relatively specifics, because I think that these changes, if we adopt, can can be drafted in legislative form for statutory changes to be considered by the House and the Senate. With regard, one of the things that in the LEOBR that's currently missing is a complaint is filed and charges are made, but it's very unclear as to how those charges come about and what role and who's making the charges based on the facts that are delivered to them. It varies by agency. One of the practices that I would like to put up as a recommendation for consideration, certainly, well, I would say it's under current law in Baltimore City, local jurisdictions have independent, some in Baltimore City, I think Prince George's County or Montgomery County, they have civilian review boards. They're already established. We wouldn't recommend anything with regard to that. But I think there's a way from what we've heard out of New York City to get citizens more involved. And what that recommendation is require that counties establish and maintain what we would call a police accountability board. And the board wouldn't supplant the civilian review boards, but it would give civilian representation and insert them at different points in the process. This board, which would have civilian representation, sorry, I got a frisky dog in here, is civilian representation, as well as we would include on this board to look at the resulting charges from internal affairs. So internal affairs would do the charging, forward it to a board, and on this board we would utilize some citizens. We would utilize a citizen. We would utilize a representative appointed from the state's attorney's office, from the public defender's office, from the community, from the county attorney's office, as well as the police department who oversees it. They would actually take the investigation and review through a charging committee what charges should be leveled. So this is a way to get citizen involvement at the charging process. They would sit on a panel of 5 and they would review cases that involve the public or integrity or violation of criminal statute. And they would charge based for sexual harassment, racial harassment. They would review the cases, and the charging committee would have several authorities here. They would have the ability to say to internal affairs, look, we need you to do more work on this and do a more thorough investigation. These things are missing. We see deficiencies in agency training that leads to this. We make recommendations. We'd ask that the agency respond to that and address that. But the charging committee would ultimately be responsible for charging officers with regard to violations of policy and make recommendation, the initial recommendation for the law enforcement officer's decision whether he would accept or not accept.
I think he's on mute.
Yeah, did we miss him? Sean?
Yeah, he went back on mute.
Okay, hold on a second. Let me handle this so the dog's not disturbing us. I apologize. Working for
While Sean's taking a pause, Mr. Chairman, is it your idea that we would kind of deal with these one at a time, one broad area at a time?
Yeah, that may be a good solution before he goes to the next category, which would be hearing boards. We can talk about this charging first.
Great.
Sorry, this committee would meet. They'd have representative different stakeholders who would weigh in. They would make the recommendation of what violations occurred and what the punishment would be. That punishment would be offered. Once its final decision is offered, the officer would be presented. If they accept it, that's the punishment. If they don't accept it, then they would go on to a charging board. That's the concept, but it is an improvement over the current process where within an agency There is nothing designated in the law as to who levels the charge against an officer, who reviews it, who's overseeing internal affairs, who's making sure that an investigation's done thoroughly. Currently, if in an agency, if internal affairs doesn't do a thorough investigation, and decision is made to not sustain a charge, there's no oversight. There's no one really looking at that except in a couple jurisdictions. So with that, that's kind of a brief explanation of the idea of creating in whatever statute, law enforcement officer bill of rights or police officer accountability statute, the idea of a charging committee with representation outside the agency from the public defender's office, state's attorney's office, county attorney's office, a citizen, and as well as a member, whoever it is that oversees police misconduct in the agency. With that, I'd kind of submit it for any questions or comments or concerns.
All right, well, what we'll do, Commissioner, is that we'll just ask for questions after each section that you hit. So any questions on the charging process, the proposal?
Sean, or Mr. Chairman, I'm sorry.
Yeah.
It's hard to know when you're being recognized and not stepping on other people.
Yeah, just go ahead. Yeah, step with a few of us. So just unmute yourself and talk.
Yes, sir. So Sean, I kind of like this proposal from the aspect of consistency and fairness within an agency. So oftentimes you hear from police officers or from police unions that officers are treated differently when they commit the same violation. So here you have the same people kind of making this decision. I know it adds an additional burden to a department, but really consistency is all you're asking for as a cop. You know, if I did something, fine, I'll own up to it. I want the punishment. I'll take the punishment, but just make sure somebody else does the same thing, that it happens to them and it's not different because of somebody they might know or any discrimination issues. We had that in Baltimore City in the late 90s. As you might have been aware of, Sean, where there was accusations that minority officers were treated more harshly.
Yes.
Than their white counterparts. And we did something very similar to this to address that issue. So I think this charging committee concept, to be consistent and for it to be in the LEOBR, is something that would benefit the officers as well as the department. So
the concept comes from what we saw in New York, where civilians were involved in from the Mullen Commission, as well, which is where citizens comes from, as well as we did something like this similar in Baltimore to address that very issue. It was not involving outside agencies, it was completely internal. So this is a real evolution of that, but it was to ensure consistency in charging across gender, across racial backgrounds, to ensure that officers were being treated. Also, with the outside, by bringing in outside entities who are stakeholders in the criminal justice system, it does create some transparency with the process. If an officer is not charged with a violation, you know, it's not just the agency. The idea that the agency covered something up would be hard to sustain because we'd have 5 different entities looking at it.
Any other questions on the charging? Let me ask this question, Sean. Is there any way this committee could have any influence or impact on the authority of the state's attorney to charge?
Well, I think this is separate. So I did this more as in the administrative process. I think the state's attorneys, because as you know, Your Honors, you served in that role, they're going to retain their own discretion to charge criminally or not to charge criminally. I think that ultimately, with regard to that, that's another area that we'll have to they could certainly refer. I think the committee could refer if they saw a violation of criminal code, something to a state's attorney for their review, but the state's attorney is going to be in the room, or a representative in the room who would take a look at these things. If they saw it, they would be able to make that determination separate and apart from the administrative process.
Yeah, just a question. Of course, the public defender would have to be a little uncomfortable with being part of a recommendation for charging, obviously.
Yeah, I think it cuts both ways. And look, I think within our state currently, you have you would have some that would say in some jurisdictions, states attorneys are less inclined to charge an officer. Others are more inclined to charge an officer. I think you can get a balance, but I think the idea of having a public defender or representative from the office, they could appoint a member of the bar, Your Honor, or somebody else. But having them in the room, I think it's just it's a pretty basic look of this is the conduct of the investigation, and does it sustain a violation of policy? And you'll have 5 votes to help determine that, and the majority would carry the day is the concept.
Sure.
So,
Sure. All right, let's go to
but
the
no criminal implication. It's the administrative process.
All right, okay. Let's go to your next area, hearing boards.
So in the current law, the LEO board hearing process is specified in law. If an investigation finds a charge should be levied, that's when it can result in demotion, dismissal, transfer, a disciplinary action. They're entitled to a hearing board. In essence, if the agency starts an investigation, then the LEOBR attaches, and in order to, if an officer does not accept punishment, they are entitled to a hearing board unless they are convicted of a felony. And a conviction under Maryland law does not include probation before judgment. A current law dictates the hearing boards are 3 voting members who must be law enforcement officers unless it's a local jurisdiction has negotiated to have 2 civilians on the board. It's option. In Maryland, only 1 jurisdiction has decided to have citizens on trial boards. You heard from Mike Davey today, 2 years after the fact. They're still in training. That's yet to take place, but Baltimore has adopted that. They have the ability to put 2 civilians on a training trial board. The law affords the opportunity for civilian representation on a hearing board, as we talked about, but it's discretionary and there's other requirements. So a couple recommendations that we have with regard to the trial board. We would require that every hearing board be comprised of at least 5 members, 3 who are law enforcement officers appointed by the chief, and 2 members who are civilian appointed by the accountability board. So when you take this in conjunction with the charging committee, a civilian, separate and apart from who would sit on the trial board, but a member of the public would be a part of the charging process and the review of cases. And then at the trial board process, you would have 2 of the 5 members from outside the agencies be appointed by the County Police Accountability Board. These would be trained individuals in the LEOBR, familiar with the police practices. All hearing board members would have to be trained by the Maryland Police Training Standards Commission. That's different from today. Currently, each agency has a discretion whether or not to train the members they select for trial boards in the hearing board processes. And that does result in procedural errors and confusion about the role of a trial board. So this would increase the training of all trial board participants, including citizens, putting them on the board. We would recommend that the statutory authority to form alternative, currently under statute, you can form an alternative trial board process through negotiation at the table. Because we think that you're creating different processes in different jurisdictions, which creates citizen confusion, we think that those clauses of contract should be honored to the end of the current contract, moving forward, they would not be able to be renewed or renegotiated. The trial board process would be consistent across all the state's jurisdictions. 5 members, 3 members appointed by the law, or 3 members appointed by the chief, 2 members who are civilians appointed by what we would form as the county's police accountability board. We would add to current law that officers not entitled to a hearing board if the officer is convicted of a misdemeanor assault or theft in addition to a felony. We would recommend including probation before judgment. it's a plea of guilty. So we recommend that that would have the same effect, much in line with what Mr. Davey has indicated. They wouldn't necessarily be opposed to, and in line with what the state's attorney has requested. But we would limit misdemeanors to assault and theft as well as felonies. And then, of course, all hearing boards we require them to be videotaped. Right now, they're often just transcribed. They're open to the public, and that a record of the hearing process be made available, because we have consistently heard throughout the testimony across the board that these are closed hearing boards. There's not transparency, and part of our mission to restore trust in policing is to shine light on the processes by which officers are disciplined. We're doing that by putting citizens involved, recording these hearings and making them open to the public. So that's the changes that we recommend with regard to the makeup of hearing boards. And I open it for discussion.
Sean, so you went through a lot of issues. I guess I'll try to go through them
Sure.
one at a time. When you say cannot negotiate the makeup of the hearing board, are you just talking about the 5 members? Because there are other things that unions have been able to negotiate over the years, that I agree with Mr. Davey in that, you give something up at the bargaining table to get something. That's negotiations. And now to have it unilaterally taken away from you. So are you only talking about the 5-member board being the part that is set in stone?
Yeah, so at this section, I think there might be one other recommendation with regard to final say, but only 2 jurisdictions have taken the ability of a chief to raise a punishment. But at this point, yes, that's the recommendation we're making. It's not that you couldn't negotiate strikes, for instance, of a trial board member, but it would be the makeup of the trial.
Or how it might be random, how you have a computer
Correct.
select. Okay.
Correct.
Thanks.
This is just the makeup. This would be that a agency could not negotiate with the union that we would have a 1-person trial board with no civilians on it. It would be, you make this uniform across the board, that the makeup is 3 law enforcement officers, 2 civilians, open to the public. You couldn't negotiate those things.
Okay, and regarding your misdemeanor assault and theft proposal, is that for a line of duty? Misdemeanor assaults and thefts,
It would be any assault where an officer has been charged criminally with assault. So yes, if you're charged in the line of duty with assault, if you were charged in a bar fight, the commissioner could review it and make a decision based on that. If you've been convicted in a criminal court.
and the PBJ, is that as
Domestic violence would fall into that as well.
Okay, the PBJ, is that as it relates to felonies or all PBJs?
No, that's how it relates to felonies and those 2 classifications of misdemeanors, assault and theft.
Okay, I like your idea of videotape. I think that's, the time has come, right?
Right.
And then you propose making those available, those trial boards, making them available with the appropriate redactions of witnesses and stuff like that, public, because, you have victims that might be testifying as well. So I think we need to make sure if we're going to release something publicly, that, we protect those type of folks.
Okay, currently if trial boards are open to the public, individuals can sit. I think the identity can be protected for confidential informants. But I don't think there's anything we're putting in that would prevent a hearing officer from doing something with regard to redacting identity if it's safety.
And I think it's important to note that, once again, Baltimore City is kind of an outlier when it comes to trial boards being public. They used to be public, and I know the media used to set in on them.
Yeah.
And then all of a sudden, randomly, they said they weren't public and stopped them. I know now they hold them. They've held them at City Hall. They've held them at the War Memorial Building. They hold them in public places now, that make it more available.
Sean, let me ask you a general question.
Yes, sir.
Are these proposed changes to the bill, are there any consensus around them right now? These are, I like the proposals. I'm just wondering
No,
how it's going to be received by the General Assembly and others.
to that, I don't know. I think counsel for us is also shared by both the Senate and the House. They have to take a look at whatever it is. I mean, I don't know. I haven't lobbied the committees on this issue or anything along those lines in a vote count, but I think it's more along, these recommendations are based on what we've heard. So we've heard a state's attorney talk about probation before judgment as a problematic. We've heard the police chief talk about it as problematic. And then we heard Mr. Davey, I think in real candor, saying he understands some of the issues with regard to going through a criminal hearing where the standard of proof is higher at beyond a reasonable doubt, as opposed to just a mere preponderance, having someone convicted there and then having to then go through a trial board process for a serious matter like a domestic violence incident or theft. As Commissioner Roby would know, and others on this call would know, you really can't put a police officer on the stand who's been convicted of a crime of moral turpitude, because it goes to credibility. And so the idea, if you're convicted in court of theft, because it's under a certain threshold, I guess it's 500 now, maybe it's 300, you would still have to go through a trial board process. For prolonging a process by which an officer is of real no use to the agency or citizens with that conviction on the record. So I haven't gotten to, no, we haven't. We'd have to make these recommendations and put it forth for the legislature to consider, but that's just a separate process. But I think based on the testimony we've heard, Your Honor, these are consistent with what we've heard from witnesses before us about some of the changes and some of the concerns they have with the current statute.
Sure.
Your Honor,
Yes.
I was just hoping that we could run this by the Maryland Chiefs of Police and the Sheriff's Association before it gets too far down the road. I wouldn't want to get snowballed by them with this is going to be more of a problem than we really anticipated. So the more people we get on board, the better.
Sure. And I think that's fair. And I think, as we start to move down this road, I'm sure officers want to be heard too. I would suspect we'll have some opposition. These are significant changes.
Oh, yeah.
So, and look, a lot of this has to do with who controls the process, right? Right now, the process is pretty much controlled by command. They do the investigation, they do the charging, they select the trial board, they determine guilt or innocence, they determine punishment, and the chief can up punishment. It's not determined by the FOP, it's not determined by the Office of Law, it's what the statute, where it puts it. So if we're looking to, I think based on what we've heard, Chief, these are some of the changes that have been recommended, and I'm just putting them forth for consideration.
All right. I think the next area, if no further questions here, the next area is the training and standing. Yes.
This is Commissioner Rob. I have
right.
a couple quick questions as it relates to community and transparency and trust. I think are you thinking about also with these boards having a process, how the community representative was selected, and is it going to be a timeline, not a on this commission or on this forever? You know what I'm saying? So
yes,
will it be a process of how you select it and why, and the training process and who they are, and the time that you gonna will be a part of this trial board?
Those are great questions. Yes, that is contemplated that people would serve a term as they'd be trained, they'd be selected, they would be trained uniformly across the state by the Maryland, and we're going to get to that in the next section, by the Maryland Police Training and Standards Commission. They would, this board would supply people for the charging committee as well as for the trial board process. And you're right, they would be, they would serve a term. They wouldn't be on indefinitely.
Great, thank you.
All right,
Yes,
all
ma'am.
right. Yeah, let's go to the Police Training and Standards Commission.
So the commissioner was clairvoyant. That's the next section. Under current law, one of the explicit duties of the Maryland Police Training and Standards Commission is to train civilians on the LAOBR and police procedures. What we would recommend is to help, because we got a lot of police agencies. I don't know, Gary, it's over 150 in the state, I believe. So the officers are receiving some training, a lot of training, or no training before they serve on these boards. So we would make the recommendation that the Maryland Police Training and Standards Commission not just train civilians, they train police officers. The commission would maintain a roster once an individual's been trained, whether it be law enforcement or civilians, that can be chosen to serve on a charging committee and on a hearing board. And the Maryland Police Training and Standards Commission would provide staff to the charging committee if need be.
Okay. Any questions here?
Well, Sean, since that comes under my current job title,
Yep.
or
Yep.
in the department that I'm now involved in or work for, providing staff is going to be a problem.
I understand.
I think consistency in training is important. The chief knows, Chief Roby understands. We do this for a lot of positions within law enforcement. For example, first line supervisors all have to receive training approved by the training commission. Field training officers all have to receive training approved by the training commission. So I would suggest that we allow the training commission to approve the training. So the larger agencies who need to train 100 or 200 people can develop their training, get it approved by the commission. And when you teach on behalf of the commission, you have to be, as an instructor, you have to be certified by the commission as an instructor. So we could have the training commissioner basically administer it, but not have to do it.
Yeah, that's a very good suggestion. I think that's reasonable. I would say that with regard to, when I say staff, I meant, I think it's not worded very artfully. What they would do is, once individuals are trained, when a hearing board, when a charging committee is convened, they would assign the person off the list to attend the charging committee. So they wouldn't actually have to send their own staffing there. If you had 10 members who were trained in Howard County, Howard County would contact the training commission, said we need a civilian for the charging committee. They would say, okay, here's the name on the list.
Yeah, like I said, I don't have a problem with that. And if
Okay.
you want the commission to be involved in the training of the civilians and of the officers appearing on the trial boards, I would just suggest that it be training approved by the commission.
I understand. Yep.
All
Okay.
right. You may want to make some notes and maybe adjust the language a little bit there.
Yes, sir.
All right. How about terminations?
So under current law, a chief is explicitly authorized to regulate the competent, efficient operations and management of a law enforcement agency by any reasonable means, including transfer and reassignment if the action is in the best interest of the agency and not punitive. Additionally, case law exists that authorizes a chief to terminate an officer if it's for the competent and efficient operations and management of the agency. I'm not sure Baltimore City agrees with that interpretation, but there is case law that is clear. If an officer is not charged, and there's two cases we can cite, I think one is Canalesco, if I'm pronouncing it right. But the courts, the appellate courts have already held, if an officer is not investigated as part of a disciplinary proceeding A chief can fire that officer for performance reasons or other matters that may arise. What we would do to help clarify that, so agencies don't have any misunderstanding about what they currently have the right to do, is to expressly authorize a chief to terminate, demote, in addition to transfer and reassign, for matters that are unrelated to a disciplinary proceeding. That's the current law. We would recommend that be made explicit in statute. For instance, the matter we had, we discussed of an officer sitting in jail who was awaiting sentencing after pleading guilty in a matter. This would make it clear, because the officer is not able to report to work, they could terminate them without having a hearing, which I think is what the current law says, but this would clarify any misunderstanding with regard to that.
Any questions? All right.
All right.
What's next? Expungements?
Yes. Under current law, an officer can have expunged any personnel record where the officer was exonerated, the allegation charges were deemed to be unsustained or unfounded. There's no limitation on the type of allegations that can be expunged. However, an officer must wait 3 years from the final disposition of allegations and charges. We've heard objection to this part of the statute from Public Defender's Office, as well as the State's Attorney's Office, as well as the Police Department, with regard to some matters of which a unsustained finding doesn't necessarily mean it didn't occur, but they didn't have enough to find culpability. And in certain types of behavior, patterns of conduct may be helpful in an investigation. So our recommendation would be only allow charges that were exonerated or unfounded to be expunged, not unsustained. Require a 5-year rating period from final disposition to give a little bit more time if a pattern is to be developed. And then prohibit formal complaints involving excessive use of force, discourtesy, racial harassment, sexual harassment, or violation of criminal statute from being expunged.
Now, what's the reception of the department on these recommendations?
I mean, we haven't run them by, but these are similar to the recommendations, I think, that we have heard with regard to expungement from the Public Defender's Office, State's Attorney's Office, as well as advocates. I think it's consistent. Look, there's a right I think it's reasonable if an officer has been exonerated or it's been found to be unfounded, which means it never occurred, that there not be a record of the investigation around forever that could be used against them. And we're going to get to changing some terms to make it consistent, but there has been issues with regard to an unsustained may just mean there was a bad investigation or an unthorough investigation and it was unsustained. It doesn't mean it didn't occur, it just means there's not enough to move forward on unsustained. So it's a little bit of a different category. It's a decision to not charge. And we're going to get to that in a minute to help clarify those terms where there's a lot of confusion currently amongst the legislature, amongst the public with regards to what sustained and unsustained actually mean.
Okay.
Sean, this one causes me a little bit of concern regarding whether it would have a chilling effect on officers who work in particularly high crime areas that have to do a whole lot of policing, right? And I saw this many years ago, a concerted effort by certain drug organizations to get certain officers moved from the community by just making a bunch of complaints. And the department, so now you load up someone's jacket, and what effect does this have on promotional opportunities, specialized unit assignments, those type of things? And, you know, if police departments start saying, hey, you have 10 or 15 unfounded, whatever charge might be in your jacket, I don't think I'm going to promote you, or I don't think you can go into this specialized unit. Then what that'll have is a chilling effect on people we want going out there and doing their job. I understand your intent. Maybe there's another way we can we can get to the same point regarding expungement. But, you know, if we have early warning systems in place where we're actually looking at these things, right, and calling these officers in, that might be enough. I don't want to load somebody's jacket up. And then I would defer to the lawyers on the group and to the judge. Can this stuff be admitted in civil cases? How does it impact jurisdictions? I don't know that the city of Baltimore or any local jurisdiction would want to defend a case where someone had all this stuff in their jacket that wasn't proven, yet would then come out in a civil trial. So I'd leave that to you lawyers to see what impact it would have there.
So with regard, I understand, I think those are valid concerns, and those are arguments that have been made in the past regarding this. This doesn't prevent an expungement of an unfounded or exonerated case. So if an investigation is done and they find that the officer in fact did not do what's been accused of them, then that would be allowed to be expunged. What this is trying to do is to keep in place categories of offenses that a pattern of conduct, sexual harassment, racial harassment, use of force, or violations of criminal statute like theft, that a pattern of conduct within a smaller subset of violations would not be able to be expunged, so that a investigator could go back and say, wait, I have 3 other offenses. A woman allegedly she was pulled over by this officer.
Yeah, you're right there. I got you. So maybe we want to list those categories rather than, you know, a guy who gets, you know, some group decides, hey, Officer so-and-so's on this corner every day. We can't do our business because he or she's out here doing their job. We load them up with whatever, because you can make anonymous complaints. So yeah, I got you. I can see that point there. Maybe we want to get more specific.
Yep, we can do that. I think in the 3rd bullet point in the outline that I provided, I think you raise a good concern. We're not trying to prevent, we're not trying to take where an officer's clearly not done anything wrong to be bogged down. But we are trying to keep certain subset of categories where a pattern could help an investigator. That's what we're trying to look at. So I understand. All right.
If I could comment, Sean, I keep hearing the word discourtesy coming up, and I don't know if any police officer, I don't care how good they are, including yours truly, that hasn't been charged with or a complaint alleged of discourtesy. Anytime you stop, in this day and age in particular, you stop a car for speeding, all the grief I've caught, and I know it's a lot worse now talking with the officers, they're going to make a complaint that you were discourteous because you didn't agree with them. So I just think we need to be careful how we stick that in there too. It's the lesser of the things that you and Gary were talking about, but it's a concern.
That's fair. And maybe that's something that as a committee, we look, it's going to be around for 5 years. You can certainly find a pattern. If an officer's had, you know, Chief, I think that's a fair point on discourtesy. It's a little different, and you're going to get those if you're an active officer. And I think allowing an extended period of time before it expunged could still achieve the purposes of establishing pattern without bogging someone down over a 20-year career.
But I can tell you about some of our officers that you could have written a book about the discourtesy complaints they got. So having it tracked, and certainly, you know, it needs to be done.
Yeah.
Just how it's utilized, though.
No, that's fair. That's fair. Okay.
And let me say again, we're going to continue to look at all of this between now and our next meeting before we make any final decisions at all on where we are. We're just asking Sean to just go through the recommendations. I will defer to the commission. I know we generally go until 4. We've got a few more items, just a couple more items on the agenda, and I don't want to take advantage of the time. So if we need to defer the last couple or the last few to next week, we can do that. But if everyone's prepared to continue on, I am. But again, I don't want to abuse the time of others. So Sean, why don't you go ahead and we'll see how far we can go.
Okay.
Normalized reference to charging.
Yep. Thank you. You're better than me keeping track. All right. normalized reference to charging. This is, I think, is an important area of something that I've witnessed. We've witnessed as a commission. I've seen it in the legislative hearings as well. And that is under current law, under current practice, agencies use the term sustained for a violation of which they believe they can present a prima facie case to prove. It's like an indictment in the criminal world. It's sustained. It doesn't mean it's taken place. It just means they believe it's taken place. And that is the impetus for a charge. So sustained matters result in charging. So sustained, not sustained, unfounded, and exonerated are generally used by agencies across the state to determine whether an officer faces discipline and a trial board. However, these terms are found nowhere in the LEOBR to be defined, and they are used in a couple clauses that were added through amendment late. But it's not standardized in the law. It's just kind of the practice of agencies. And I believe what we've witnessed in watching testimony from advocates, public defender's office, as they're trying to decide these what matters should be disclosed to the public, the term sustained, not sustained, sustained seems to carry more weight than in actuality it necessarily has. So what we're trying to do in this section would be to normalize and standardize as terms of art in state law the following. Administrative charge. This term would mean a formal accusation of misconduct seeking discipline against an officer. It would replace the term that's in common parlance used as sustained. So it's more precise. If the charging committee decides to charge somebody, it's called administratively charged. Not charged. This means a determination to not bring an action against an officer. This will replace the term not sustained. Unfounded. Unfounded, the term would mean a determination that the allegation against the law enforcement officers are not supported by fact. That's what I think Gary was referring to. Not supported by fact, while already it's already used. This definition would then be put into statute where it's not in statute. And exonerated means that it to be acted in accordance with the law and agency policy and therefore violated nothing. Similar to the term unfounded, this would be added as a definition in the term that's already used, would be put it into law. I believe that this will clear up a lot of confusion of the public and people who aren't practitioners in this area, that as well as for officers, that an administrative charge, you've been charged with something administratively, as Mike Davies said he had been charged, but the term sustained carries greater weight. It makes it seem as if the evidence it doesn't just support it, but it's almost a finding. So this is to help clarify the statute, and it would just be putting these into law so everybody knows what the 4 categories are. There is a 5th category that should be added on here, and that would be a agency training deficiency. Agency training deficiency would be a finding that the officer acted in accordance with training, but the result was a result of a bad protocol within the agency. For instance, in the case in Baltimore, in Freddie Gray's matter, there was no requirement to that had been communicated to seatbelt a prisoner in a wagon. That could be deemed a training deficiency of the agency, which would need to be corrected. And this is something that comes from Minnesota, that an advocate pointed out that they have this category of a training deficiency that the agency can be alerted to in the review of these cases. So those would be the five categories, and it's just for clarification.
Now, where would deficiency, agency training deficiency, is that susceptible to subject to being expunged?
Well, it wouldn't be leveled against the officer, but in the review of the case by the charging committee, because now you have a group from outside the agency reviewing this, eyes looking at the agency's policy may say, wait a minute, it doesn't make sense. Why aren't we, for instance, ensuring that prisoners are safely transported and seatbelted, or if they're unruly, put into a different wagon and put into a cage car where they can be transported safely. Then the agency, they could make alert. It's not necessarily a finding against the officer, but it is a finding with regard to the agency's protocol to say, look, agency, take a look at this and report back to us on the rationale for this policy or a change that may need to be made.
Mhm. And unfounded means what, insufficient evidence?
No, it's that unfounded would be it's not supported by fact. I allege that that Officer Wilson on August 25th used excessive force, and Officer Wilson's able to show that in fact on that date she was on vacation in Rome and wasn't there. So the charge is unfounded. It's not supported by fact. Exonerated, it's a small difference. Exonerated means, yes, Officer Wilson was there, but she acted in compliance with the applicable use of force guidelines, using the lowest applicable force, and therefore is exonerated, acted in accordance with law and agency policy. So that's the difference. One's unfounded by fact. The other is, no, something happened, but they've been cleared of any wrongdoing.
All right, so where is a category when you have those close cases where you just haven't met the standard? There's some evidence that it occurred, but
Yep.
overall on balance, you just don't want to.
Not charged.
Not charged?
Yes, sir. That means a
Okay.
determination has been made to not bring an administrative charge against the officer. It may be that you have a real credibility issue with the witness. You have conflicting reports from witnesses. There's all sorts of, that's the current unsustained category, but it's not charged. It doesn't say that, it doesn't give any weight other than the charging committee or the agency decided to not bring a charge based on the results of the investigation. It doesn't exonerate the officer. It doesn't say nothing happened. It just means it's not believed they could prove it at a trial board.
All right. Any other questions? All right.
Okay.
Yeah, keep going.
Issue of subpoenas. We've heard this consistently. It sounds like FOP counsel doesn't disagree. Currently, an officer investigating misconduct claim does not have the express authority to issue a subpoena. Subpoenas may be issued to compel witnesses or evidence by the hearing board, but that's after a charge has been in place. What we would do, and this is consistent with the state's attorney, the police department, and it sounds like where the FOP and advocates are, it would authorize an investigator, an officer investigating or a civilian investigating a misconduct claim to issue an administrative subpoena that would help them get evidence in proving their case. If, for instance, they could have a subpoena issued to a store for the videotape of what happened on a corner at a 7-Eleven. They don't currently have that authority. And by the time the trial board gets it with the delay investigations, that may be destroyed. So this would, and much like the subpoena power our commission has, if they don't get it, they could go to seek it, a subpoena from a court in accordance with this act. So it's to give a little more, it's to give a tool to investigators of misconduct claims, a tool they currently don't have to ensure they get a complete investigation. And this does seem to have the support of all parties.
All right. Any questions here on reaction to that? All right. Just two more areas here.
Yes, sir.
You have the complaint process is next.
Yes, sir. So in the complaint process, currently a complaint that alleges brutality must be sworn to under penalty of perjury by an aggrieved individual, a member of the individual's immediate family, with firsthand knowledge of the event, or a parent or guardian. And complaints alleging brutality must be filed within 366 days of the event. It's interesting. This is separate and apart from every other violation that an officer could commit. We would recommend, based on testimony of the state's attorney and the police department and advocates, that we would strike the requirement that this be a complaint sworn to under the penalty of perjury. In reality, no one's charged with perjury for under these complaints. It's unnecessary. It creates a hurdle to the filing of the complaint. We would authorize an attorney capacity as a prosecutor or a representative of the aggrieved party to file the complaint. So if a prosecutor sees pictures in the course of the prosecution of a defendant that look like excessive force was utilized, they review a videotape where they believe excessive force has been used, the prosecutor could file the complaint of excessive force, as opposed to the agency not being able to proceed because a complaint's not been filed. It would authorize the chair of the county police accountability board to file a complaint on behalf of an individual, so that if an individual comes in, and it would authorize complaints alleging brutality filed within a 3-year period rather than a 366-day period. Currently, it's a tighter time frame. So this is just to broaden the way and really put it more in line with the way other complaints can be filed with an agency.
Yeah, Sean, I think the 365 has been basically thrown out by the court.
Yeah.
In the Andrews case, I believe it was.
Yes.
Because it says the department may, so now they get to choose whether they would investigate something. Am I correct in that?
Yes, and this really kind of gets us in line with the law, but I think look, excessive force is as we're consistently seeing in the news and with the advent of body cameras, this is a real issue. And the current way the LEOBR drafted, I think it can fairly be seen, put some hurdles in the way of a citizen having to write the complaint out, swear to it under oath, and no one else can file it but that individual. This is opening this up to address what we may be seeing but unable to get at.
I don't think it's anything new that's not already been
It's
addressed by the court. I think that's already been addressed by the court and allowed to happen.
Yeah, it's clarifying current, I think, what the interpretation of the courts has been. Okay.
All right. Any other questions here? All right, Sean, you have the last category. If you can run through those recommendations, and then we'll wrap it up.
I'll get us through the home stretch here. So these are important recommendations. We heard from the police department, we have heard from the state's attorney's office, and we have also heard from it sounds like the FOP, not in opposition, the idea of authorizing a civilian employee of a law enforcement agency or the governing body, that is the jurisdiction in which the agency rests, to conduct an investigation, including the interrogation of a law enforcement officer. Under current law, only a sworn officer, unless or if requested by the Attorney General, may conduct an investigation. So we want to fix this. This doesn't seem to be much dispute around this, but this is an important change to strengthen the ability to hold officers accountable and bring belief in the integrity of these investigations. Any questions on that point? Okay. Provide that in the context of an investigative file, a law enforcement officer may exclude from the file the identity of confidential sources. That's current law. However, we would adjust this. Currently, the law enforcement agency may exclude, they have to exclude exculpatory investigative material, but they do not have to exclude, they can exclude a non-exculpatory or information. It's a weird glitch, Chief, but in essence, the agency has to give over exculpatory information, but anything that is inculpatory, they can hold back. That doesn't create a fair process for the officer charged or for belief in the process. We believe, in essence, like good states attorneys' offices do around the state. I'm sure you did in Prince George's County, Baltimore County does, Baltimore City does. The entire investigatory file, including exculpatory and inculpatory material, would be handed over, as well as charges and disposition of punishment. So we would protect confidential sources, but require that the full file be handed over.
Sure.
Any issues on that?
Yeah, that's a progressive move. Yes.
Okay. Provide The next is provide that an officer subject to interrogation must obtain representation within a 3-day time period. This 5-day time period is a big issue with a lot of advocates. It's been raised consistently as an issue with the LAOBR. Practically speaking, for practitioners and for investigators, we understand that this was put in place to ensure that an officer didn't needlessly postpone an interrogation more than 5 days by saying, I don't have counsel. So they put a time frame in originally of 10. It's been reduced to 5. We're now taking it to 3 days, that they either obtain representation or they can be compelled to give a statement. The reality is, I think Gary and the chief would tell you, the accused is usually the last person anybody wants to talk to. They want to get their investigation done and talk to it, but this is tightening the time frame. It does not look, this looks like this is met with general approval from advocates to the FOP, or at least some counsel who practice for the FOP in this area. Under law outside the LOBR, an officer is entitled under Weingarten rights to counsel if they're going to be interrogated anyways. So we can't do away with that. But this would give a 3-day business day, tightens the time frame. We would require that interrogations of officers be video and audio recorded as well as transcribed. Under current law, it leads it to the discretion of the agency whether to write it, tape it, or transcribe it. As a practitioner in this area and people who have practiced in this area, I think they would all indicate that video and audio, which is able to be done now pretty easily, creates the most accurate transcript of the record. And it's important that we get it right, that what the officer says is accurately recorded for trial boards as finders of fact as well as for investigators.
John, does that include all witnesses?
It does not. It does. We didn't go that far. We could go that far.
I mean, we might want to consider what if they're going to develop the equipment and bring it into the interrogation room. You know, we do it for all witnesses now. I mean, they do it in serious cases. Homicide, I think, is required to do it. Do we want to think about doing it for witnesses?
Okay.
Because way, if someone's not available, right, it cuts both ways. If someone not available doesn't show up for a trial board as a witness, it cuts both ways for either side to be able to say, hey, now you're not just getting a piece of paper of what they said, because that type of testimony is admissible. At least the trial board would have the ability to look at the person while they gave that statement. And I think it might clarify one way or the other for either side.
Okay, we should have some discussion around that. I'd be interested in also hearing maybe from internal affairs, detectives, as well as defense counsel. Is there a concern that requiring a citizen to be videoed and recorded could suppress or discourage their statement? I don't know whether it would or not. Also, an investigator in the field, does it make it harder for them if an individual doesn't want to come to the department to give a statement? Does it make it harder to take a video and audio? Probably not with phones today, but just for discussion purposes. But we're doing this for interrogations. We could certainly do it broader.
It just seems that we have so much video evidence. It's now the norm. It's what people expect,
Yep.
Whether it's body cameras or anything. People are just expecting this type of evidence.
I defer to on every one of these issues, what the commission's will is. So.
Yeah, I agree with that. To the extent it's practical and possible, we also should encourage video and audio.
That could be a good compromise too, Gary.
Yeah, to the
For
extent it's
practical and possible.
Yeah, practical and possible. Yeah.
Okay. Okay, so currently polygraphs are allowed of officers. As course of an investigation, you cannot introduce it into a trial board unless both sides agree to the introduction. Therefore, they never get introduced. We would just ask that if a polygraph is ordered, that the polygraph not be administered by the law enforcement agency that orders it, to ensure that we're getting an unbiased look at it. We're not looking to change the admissibility. There was some discussion about that, but I think it kind of cuts both ways. and there's still questions about the reliability of them for the reliability polygraphs for the purposes of determining guilt, but they're certainly well regarded for an investigatory tool. Provide the chief's designee can issue subpoenas in connection with the trial board, with a hearing board. Under current law, only the chief of a hearing board may issue subpoenas. That goes to the investigatory. I think that's duplicative. I think we've discussed that. This is something Gary asked earlier. This would be the second restriction in collective bargaining, that a collective bargaining agreement may not include a provision that takes final disciplinary authority away from a chief. Under current law, there's no explicit provision barring this action. It's been done in 2 jurisdictions. The tricky part of that is, Chief Roby may agree that he doesn't want it, but Chief McElhenney, when he comes in to run the agency, has had his authority and every authority of a chief given away going forward. This would act in the same fashion as the changing of the trial board, that it would be, current clauses would be in effect until the end of the contract, and they would not be allowed to be extended. This is something we've heard from different advocates and agencies as a concern.
I would just, Sean, I would just raise my last statement that,
Yep.
It affects 2 jurisdictions in the state of Maryland, Baltimore County and Montgomery County, that I'm aware of. The counties and the police departments gave that away, and both have different mechanisms of selection of the trial board members. For example, I believe Baltimore County has a permanent trial board chairman selected by the chief. So their comfort level in giving away final order might have been different than somebody that got a random trial board chairman.
Yep.
And I think Montgomery County has an arbitration type system in their process. I'm not quite sure of Montgomery County's, but that being one argument, the other argument is, when you bargain something, no one put a gun to anybody's head when they gave them this at the bargaining table. And as a matter of fact, they probably got some lesser financial terms along the way in order to give this, and now we just take it away, not at the table. I think it's fundamentally wrong.
No, I understand that as a negotiator on both sides of these contracts. I'd be interested in hearing from Chief Roby with regard to inheriting a police department that restricted his ability to raise a punishment.
Okay.
Chief, what does that mean?
That means he would turn the chief's job down and not take it, Sean.
I would not do it. How could I take over a department that has all these restrictions that are, like, some department has restrictions right now that with what we're facing, the chief can't deal with. And don't tie my hands when I'm coming in and trying to correct problems. That's like going into Baltimore City with the current chief. If he wants to do things to make it better and he can't because of the contract, what good is it?
Okay. So there's some discussion on that issue down the road. That's a good issue. And then finally, what those changes would do is that the recommended actions would only apply prospectively. They would not have effect on a current bargaining agreement that's in place, but it would not allow the extension of the clauses that are in conflict with the law, or the renewal of them as well. So you could finish the contract with it in place, but once the contract's expired for that year, then the law would apply. And the idea behind that is that we're going to standardize the accountability process for police officers across the state so that there's not confusion between jurisdictions. One process, one way to make up a trial board, one way for a case to progress along. Gary had raised one issue prior to this in discussions with regard to the charging committee. I think it's important to discuss. A charging committee makes a recommendation of punishment. The officer can accept it or not accept it. If the officer does not accept it, it goes to a trial board. That does not preclude someone presenting the case from coming up with a different plea bargain, much like a prosecutor would Judge Williams in the state's attorney's office. The charge is offered. If it's disagreed with, a different deal could be worked out between counsel and defense counsel as more facts come to light or as the hearing progresses. It just is for the initial offer. It doesn't bind the county attorney in presenting the case from resolving the matter or the chief from resolving in a different fashion. So that's the recommendations for discussion in some detail, and we'll try to work on statutory language. I know DLS is strapped with regard to that right now.
All right, let's do this. Are you going to let who the chiefs see it at this point? See if we can get any feedback from them, and the rest of us will take a hard look at it. And then Sean, if you can, before we vote on it, maybe next meeting, we'd want to isolate any controversial or hot issues that we need to either rethink or revisit. I'd want to know that. No one wants to be blindsided. None of us want to be blindsided. So if you could perhaps in your final presentation next week, let us know any,
Okay.
again, controversial issues, that'd be fine. But what we'll do, all of us will review this thoroughly between now and our next meeting. And then we should come prepared to certainly vote on the proposal for the adjustments under this bill.
Okay. And I with your permission, I'll reach out to Mr. Davey to see any concerns they have with these, the chiefs, and then I'll try to reach out to the Baltimore Police Department as well to hear their thoughts, and the state's attorney.
That's great. All right, we have just a couple items left. Organizational administrative matters. I will say, and all of you know, that the Speaker of the House, Adrian Jones, formed a work group to address police reform, and they're holding hearings now, and they're working on recommendations as we speak. Also, Senator Smith, the Senate Chairman of Judicial Proceedings Committee, he's announced a public bill hearings for the fall to receive testimony on certain proposals. So we want to make sure that our report again is given to the Speaker as well as the Chairman Smith, so that they would know where we stand and that our report has some importance and influence in what they're doing. So with that in mind, I think that, and we've been at this almost 3 years now, and I'm just wondering whether we can begin to think about getting our final report together sometime in October. We certainly agreed before we try to do it by Thanksgiving, but I just think because of what's happening now in the state, and they're getting ready to have motions and hearings and other types of discussions, that we ought to get our report out to the governor and to the president of the Senate and the Speaker. I would say certainly sometime before October leaves us. Any thoughts on that? And I'm also going to ask for our attorneys, Mr. Keith, Ms. Casey, you all may have some thoughts in this area.
Your Honor, I would just like to know, maybe we can find out where we stand on some of the additional witnesses we've asked regarding the conduct of the GTTF and how we're proceeding on some of those matters.
Well, let's go ahead and call either Mr. Keith or Megan Casey, bring us up to date on any additional witnesses that are available or we need to speak with.
Thank you, Your Honor. Yes, I do think it's possible to get the report out in October. In terms of the witnesses, I sent an email to former Commissioner Batts. I did not hear back from him. I have his address now in Florida. So a letter went out FedEx today to him, again, inviting him to the hearing. I informed him of our next 2 hearing dates in September, hoping that he'll cooperate. And if he doesn't, we can then, I'll then come to you, Mr. Chairman, and if need be, we can subpoena him. And the same with Deputy Commissioner Palmieri. I'd held off with him because I know that Mr. Bromwich was interviewing him, and I didn't want to interfere with that. That apparently has been completed. So a letter went out today, delivered to Mr. Palmier's home address, again, inviting him, and if he's not going to cooperate, again, I'll come to you, Judge, with regard to issuing a subpoena. So I'm hopeful we can get the cooperation of those two witnesses, enforcing a state of Maryland subpoena in Florida. If that's where former Commissioner Batts is, that may be complicated. There is a way to do that. And that may be somewhat time consuming, but hopefully we can get the cooperation of those two witnesses.
Now, our next two meetings, our virtual meetings will be September the 14th and September the 28th, both again at 2 p.m. Let's hope that we can get either or both of those witnesses at our next hearing session. But if we can't, certainly by the 28th, and let me know, Mr. Keith, if I need to sign a subpoena, well, I'll do it. Yeah, just let me know. I'm available.
Will do, Your Honor.
Okay. Are there any other comments that either you, Mr. Keith, or Ms. Casey has?
Not at this time, Your Honor.
No, Your Honor, thank you.
All right, great. Now, you heard counsel say that he thinks that the commission can get their report out maybe certainly on or before the end of October. Let's shoot for that. If we can't, we can't. And I would ask all the commissioners, if you have questions about any of these issues that I went through that we want to put in our written report, again, field questions, send questions among the commissioners as well as to our attorneys, and we'll certainly discuss it at our next public session. But we want to work hard and read this proposal and any other information that we want to discuss, or issues we want to discuss at our next meeting. Okay. What else do I have? I don't have anything else. Any other items before we ask for a motion to adjourn? Anyone? All right, then thank all of you for coming, and we certainly appreciate the public interest. I think we have a number of people on the stream, live stream. So thank you all for sharing. And if you all have any information or any suggestions or questions, please go on our website again and our webpage and contact our support people. Anything else? All right, I'll take a motion to adjourn then.
Motion to adjourn.
Second.
All right, it's been seconded that we adjourn today's session. Any discussion? All in favor? Aye.
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 All right. All right. I heard you. Any opposition? Any abstention? All right. So that concludes the meeting for October 24th. And we'll see all of you back here again on September the 14th. All right. Thank you. You may leave. All right.
Thank you.
Bye-bye.
Thank you, Judge.
Thank you.